Welcome all to the book launch webinar of the Investor-State Dispute Settlement System, Reform, Replace, or Status Quo. My name is Jayshree Mohan from the Asian Institute of Alternative Dispute Resolution, and I will be your host for this session. On behalf of AIADR, I extend a warm welcome to our esteemed panel of contributors and distinguished participants. As the organizer, AIADR could not be prouder to be given the opportunity to host the launch of a key piece of literature that we believe will find its way into ongoing discussions pertaining the fundamental question of whether to reform or replace the ISDS system and whether any changes are practically feasible, possible, or even should be made. Briefly about our institute, AIADR is the first not-for-profit member-based Asian institution that focuses on the development and advancement of ADR forums. We are dedicated to promoting the practice of ADR through affordable and accessible education and development of the profession, commencing from the Asian and African continents and reaching out across the globe. We also endeavor to spur economic growth by avoiding or reducing disputes by creating awareness and through networking among users of ADR services and practicing professionals. Before I pass the floor over to the first speaker, kindly note that at the end of the webinar, participants will be given a discount code which would entitle them to purchase a digital or hard copy of this book at 25% off the regular price. Special mention to the publisher Walters Kluwer for this discount code. Kindly also note that should you have any questions for the panelists, please type in your question via the Q&A button at the bottom of the Zoom screen with the name of the panelist it is directed at, if any. We will address these questions at the end of the webinar. Before I pass the floor over to the first speaker, we regret to inform that Mr. Ben Beaumont, who was supposed to join us as the moderator for today's webinar, is unable to do so due to medical reasons. He conveys his sincerest apologies and best wishes to all the contributors and participants. On the same, we wish for his speedy recovery and hope to collaborate with him on future projects. Without further ado, I will now introduce our very first speaker and contributor, Dr. Shahrizal from Malaysia, who contributed the chapter on Reappraising Access to Justice in ISDS, a critical review on state recourse to counterclaim. Dr. Shahrizal is a legal academic and ADR practitioner. He read law at the University of Malaya as a recipient of the Public Service Department Scholarship. He graduated with an LLM from University of Malaya and holds a PhD from Monash University, Australia. He has been awarded a diploma in international commercial arbitration from the Chartered Institute of Arbitrators UK and admitted as a fellow since 2016. He's also a fellow of AIADR and the Malaysian Institute of Arbitrators. He sits regularly as an arbitrator and adjudicator in relation to construction claims pursuant to Arbitration Act 2005 and CIPA 2012. He's the author of several publications, among others, Common Issues in Malaysian Adjudication, Guide to CIPA 2012, Cases and Materials LexisNexis 2020, and most recently, his current contribution on ISDS system, Replace, Reform, or Status Quo. He's currently acting as a senior lecturer at the Faculty of Law, University of Technology, Mara, otherwise more commonly known as UiTM. I pass the floor over to Dr. Shahrizal. Thank you. All right, then, due to technical difficulties, we'll be proceeding with the next speaker to give Dr. Shahrizal some time to sort out his slides. On to our next speaker, introducing Ms. Kiran Nasir G from Washington, DC, who contributed on the chapter on the rise of NAFTA 2.0, a case study in effective ISDS reform. Ms. Kiran is based in Washington, DC, and focuses her practice on all aspects of US and transnational dispute resolution. Ms. Kiran is counsel in the law offices of Charles H. Camp, associate editor of the Kluwer Arbitration blog, and associate editor of the ICSID Review, Foreign Investment Law Journal. She also draws on her professional experiences as professional lecturer in law in the George Washington University Law School's International and Comparative Law program. Over to you, Ms. Kiran.
Thank you so much, Jayshree. I was going to start with my remarks by telling everyone how much I appreciate this digital platform, but I'm not sure that's appropriate given the circumstances and what this digital platform has done to Dr. Shahrizal at the moment. Nonetheless, I'm really happy to be here with you, connecting from a variety of time zones to talk about a very important international topic. And on this probably very festive occasion, I'd like to congratulate the editors of the book, both Alan and Ben. Unfortunately, they're not with us here today, but they were very effective in bringing together very diverse voices at a critical moment for ISDS development and reform. And of course, I'd also like to congratulate my fellow contributors. As Jayashree kindly mentioned, my remarks today draw on chapter 6 of the book, which I co-authored with my colleague Charles Camp. And my goal today, and also in that chapter, is to highlight the North American experience with regional ISDS. In doing so, I don't wish to suggest it's the best example. We of course know it's not the only example, but it's certainly an important case study from a global perspective, perhaps because it provides lessons from experiential reality. NAFTA was first promulgated and went into effect in 1994. So sitting here today, we have the benefit of about 28 years worth of experience, including both the reform process that gave rise to NAFTA 2.0, which is in the US at least known as the United States-Mexico-Canada Agreement. It carries different names in both Canada and Mexico. But just given that NAFTA and NAFTA 2.0 collectively have lived through experience and evolution, I hope that at the very least, discussing this case study gives us some examples and ideas for how other stakeholders in ISDS crossroads could consider their options. Broadly, I want to segment my comments into 3 parts. First, I'll give you an introduction to NAFTA, the North American Free Trade Agreement, its successes and its challenges. Next, I will give you an overview of the impetus or some of the impetuses for its successor, NAFTA 2.0. And then third, I want to draw on some lessons to be learned and just some brief comments on this new era of regional trade and what this means for broader trade reform efforts and ISDS reform efforts. I'll acknowledge that NAFTA 2.0 USMCA only went into effect about 9 months ago, so there's very little that we can say about how well it's faring, but at the very least, its existence speaks volumes. So starting with NAFTA, when NAFTA first launched, again, it was in 1994, its Chapter 11 ISDS framework was considered historic for 2 main reasons. The balanced approach it took among and towards the NAFTA parties, Canada, Mexico, and the US, and the immense economic impact on the region. Just to give you some numbers to go with that, the trade and economic opportunities created by NAFTA were truly unparamounted at the time. From 1994, from when it launched, to 1998, only a 4-year period, NAFTA increased regional trade by 44% to $421 billion US. By 2010, it was an increase to $650 billion. Again, these are staggering figures. And truly that was what NAFTA aimed to achieve. If you look at the preamble for NAFTA, this was precisely the kind of regional trade that they hoped that NAFTA would bring about, and economic opportunity that would come out of it. I think in that way, NAFTA and many other ISDS frameworks and BITs and regional trade agreements share that. NAFTA's ISDS mechanism at Chapter 11 was widely regarded as its key feature because it facilitated economic growth simply by providing investor confidence, presenting an opportunity for fairness, and also predictability in its legal framework. The ISDS framework was unique in one respect, which is that it was completely balanced in its approach. All 3 parties and investors from all 3 parties were treated the same. This meant ISDS was available between US, Canada, and Mexico, and in particular, between US and Canada and investors from US and Canada. In this sense, it was unique because it was one of the first trade agreements of its time that created a balanced approach on a north-north perspective, meaning that fairly economically balanced parties were treated the same. Aside from this one unusual feature, NAFTA's ISDS mechanism was fairly standard and consistent with many of the other ISDS frameworks negotiated by the NAFTA parties in other BITs of that time. So the question is, why change it? If it was doing so well, why do we do away with NAFTA? And why was, in particular, if you followed the news during former US President Trump's presidential campaign back in 2016, 2017, one of his main platforms was America First. One of his main platforms is we need to do away with NAFTA. So why did we need to do away with NAFTA? At least that's the American perspective on this. So let's talk about how the NAFTA experience really played out. During its 27-year tenure, NAFTA was put to the test. there were some experiences that were incredibly surprising, at least to the negotiators, and they acknowledged as such, and I discussed this in the book chapter. The US and Canada in particular defended dozens of investment claims. When the ISDS mechanisms were negotiated for NAFTA, it was widely expected by the negotiators that this mechanism would protect American and Canadian investors investing abroad, meaning in Mexico, in the third party, not that US and Canada themselves would face claims. So as these claims unfolded, there was a lot of criticism for NAFTA's ISDS mechanism, including ones based on the idea of sovereignty. And so here we have fully developed economic powers, the US and Canada, concerned about their sovereignty and the piece of sovereignty that they had acceded during the negotiation process. I think we should take it as a fact that no matter what you have happening in an ISDS mechanism, the fact that it simply exists is a reflection of the fact that you've acceded a piece of your sovereignty. So this is to say that the idea of ISDS and the criticisms in the ISDS is that they emerge in the NAFTA context. The existence of that ISDS mechanism itself undercuts the American civil justice system in favor of private closed-door tribunals making decisions on use of public funds. You know, the hallmark criticisms of ISDS and a major topic in the reform process. A further concern arose with respect to the nature of the ISDS claims faced by the US and Canada. So many previously before me have exhaustively studied those cases. In the book chapter, I don't purport to undertake a full survey, but I did refer to those prior surveys and draw upon some conclusions and comments that they made. And there's a few key representative examples that I focus on in the book chapter. I mentioned 3 cases, Lowenthal Group versus US, Methanex Corporation versus US, and Eli Lilly versus Canada. Obviously, each of these cases was unique with unique facts, evidence, and claims, but they're standout examples in my own view, simply for a couple of commonalities that they have. In each of these cases, the tribunals found in favor of the state based on very fine distinctions of facts and evidentiary issues. So just to clarify, all 3 of these cases were pursued against the US and Canada, so against the fully developed economic powers. And the risk was there. The risk was inherent and present in the case as they unfolded, because the conclusions, the legal conclusions that arose through the entire ISDS process were based on very small details. Moreover, each case involved claims that challenged the legitimacy of government regulations and policies. Now, to be clear, none of those tribunals found that those government regulations or policies were problematic per se, or that they needed to be changed per se. But the fact that the tribunals were considering the legitimacy of those government regulations and policies were concerning to these fully developed economic powers who, as I said, at the time of negotiating, did not anticipate that they would necessarily be subject to that kind of scrutiny. So the very existence of these claims, meaning that the NAFTA parties, US and Canada, could face that kind of risk, and that kind of risk could be present, was alone viewed as challenging for the parties. So this is in part how we end up with where we are today. So how did we come to the USMCA? And the bigger question, perhaps for some of you, might be well, does the fact that NAFTA was renegotiated to become the USMCA today mean that NAFTA failed? And I think the resounding view is no. And this is where, coming to the book's theme of reform, replace, or status quo, I think what I would posit to you as my thesis is that a resounding reform. We don't need to replace. We certainly should not stick with status quo, but at the very least, host states need to be active and actively reconsidering their model investment agreements, including whether ISDS should be included in future trade deals and whether it's their best interest to accede, as I said, that piece of sovereignty as they think about what kind of trade and economic opportunities they want to create in the foreign and international markets. By making these decisions, trade negotiators must consider past experience, including past allegations and evidence that foreign investors may have experienced different treatment meriting damages, and that approach allows negotiators to clarify concepts and implement lessons to strengthen their globalization interests, and as part of that, ISDS. So here, what I think can learn through the emergence of USMCA is that the renegotiation process reflects those lessons learned. Today, we don't still have insights into why the negotiators might have taken certain strategies per se, but we have evidence on how things turned out. So a few key points, and I'll keep them brief. Since the release of the USMCA's text in September 2018, a lot of people have undertaken side-by-side comparisons of NAFTA and USMCA. And the resounding view from a trade and economic perspective is that not much has changed. But from an ISDS perspective, it's considered that USMCA's Chapter 14, where the ISDS mechanism isn't memorialized, reflects a lot of noteworthy shifts. So first, the biggest one, Canada has withdrawn from Chapter 14. So this means that it's no longer possible, aside from some legacy claims that could still be brought after July 1, 2020 for 3 years, until NAFTA's termination. So under NAFTA, legacy claims could still be brought, but going forward, and for new investments arising after July 1, 2020, when USMCA went into effect, claims can no longer be pursued against Canada or by Canadian investors against the US or Mexico. Another key distinction is that claimants must litigate until a final decision, and I'm quoting, a final decision from a court of last resort. So alternatively, 30 months have elapsed since local court proceedings were initiated. This is different from what we had in NAFTA itself. And so the scheme is also accompanied by a 4-year concurrent statute of limitations for asserting any claim under USMCA. So we have a narrowing of opportunity if you are the US or Mexico, or US investor or Mexican investor. You no longer have as much freedom and flexibility under the USMCA as existed under NAFTA. And a final piece of departure that I'd like to highlight is that from NAFTA, the USMCA provides an asymmetrical fork in the road provision. And let me break that down for a moment. If during local court proceedings, an American investor, and again, we're only talking about American and Mexican investors in this ISDS mechanism, but if in a local court proceeding, an American investor alleges a breach of the USMCA itself, as opposed to a breach of Mexican law, this will bar any right to arbitration under the USMCA. The USMCA does not have a parallel provision concerning Mexican investors. So what you see inherent to that is that the dispute resolution procedures and the scope of investor rights based solely on nationality are different. So what that ends up meaning is that balance is no longer present in the same way that it was previously present in the USMCA, where in NAFTA, when everything was more balanced and clear between the three parties. Here we have no longer a balance or an equal treatment, but nationality itself can be determinative of the rights available to the different parties. So even though in principle, many of the same substantive rights are present in the USMCA as compared to NAFTA, there's a carve out not only based on nationality, but there's also a carve out for certain industry sectors, which get specialized treatment, especially in highly regulated sectors. So I'm going to conclude with just a few thoughts. One being, only time will tell how this transition from NAFTA to USMCA will impact North American trade and investment environments, and also the benefits derived by each state. But I will, for probably the only time in my life, will quote former President Trump, who tweeted after the USMCA was signed and saying, "I just signed one of the most important and largest trade deals in the US and world history." And to be quite honest, he was right. It's likely true because the USMCA is anticipated to account for more than $1.2 trillion of trade in one of the world's continuing to be largest free trade zones. But it does so in a different context than NAFTA. And so here, this is where we see reform and evolution. And I'd like to conclude that, speaking more broadly, the North American experience, reflecting that evolution, reflecting that reform process, might provide a practical example for effective ISDS reform. So I'll stop there because I know we have other speakers to hear from, but I welcome any questions or comments at the end of the presentations, and I'll turn the floor back to Jayashree. Thank you.
Thank you, Kiran. It appears Dr. Shahrizal is back and he has his slides ready for us. Dr. Shahrizal, are you there?
Oh, yes. All right, so I'm putting my slides on the screen. I believe that you can see that.
Yes.
Thank you. Yeah, thank you, Jayashree, for giving me the floor. My name is Shahrizal Zain. I'm a senior lecturer from the Faculty of Law, University Technology Mara, UiTM Malaysia. And I'm also a practicing arbitrator, adjudicator, and mediator. So this is the topic of my presentation today, which can be found in chapter 11 of the book, Reappraising Access to Justice in ISDS, a critical review on state recourse to counterclaim. Let me start with the introductions on the issue of counterclaim in ISDS. ISDS has been perceived by many as giving too much leeway, too much advantages to the investor due to one-sided nature of the claims. Therefore, the absence of counterclaims has become one of the main deficiencies in the system. A state is unable to hold a transgressing investor accountable in the quest to seek redress on behalf of its affected community. Therefore, questions abound with regard to a state access to justice when an investor is found to be in breach or in violations of its legal obligations. And these are the key issues that I'm going to go through each and every of them. Now, despite having Article 25 and 46 under the ICSID conventions, which possibly allow counterclaim to be made by the respondent. However, this is subject to express consent by the parties. And over the past 30 years, states have faced some obstacles or some restrictions in the form of tribunal jurisdictions to admit counterclaim. The first point over here. Second, the lack of express consent to allow counterclaims. Third, sources of investors' obligations. Fourth, the unilateral character of BIT. And finally, states' non-compliance with substantive and procedural requirements under the arbitration rules. So these are the 5 major obstacles or restrictions that state faced over the last 30 years when presenting its counterclaims. Now, let me start with the first one. Extending the tribunal's jurisdictions, a close connection test for admissibility of counterclaims. The issue of counterclaim was first brought in 1982 in the case of Klockner and Cameroon, where the Klockner Tribunal ruled that the requirements to establish the connectedness has to be shown by the respondent state, by Cameroon in this case, between counterclaim and the primary claim. So there's a need for the subject matter of the counterclaim to be intimately connected with the subject matter of the primary claim, as the tribunal put it, indivisible or interdependent. And again, the issue of counterclaim cropped up in 2004 in the case of Saluka in Czech Republic, where the tribunal held that it has no jurisdiction to hear counterclaim due to the lack of a sufficiently close connection between the counterclaim and the subject matter of the original claim brought by the investor. Second, the lack of express consent to allow counterclaims. So this is the requirements under Article 25 and 46 of the BIT that the parties, both claimant and respondent, will have to submit express consent in order to confer jurisdiction for the tribunal to hear the counterclaims. So typically, unless the parties provide express consent in the Bilateral Investment Treaty, BIT, the tribunal will not exercise jurisdictions. And under the system created by the ICSID Convention, based on Article 25 and 46, consent by both parties is an indispensable condition for the exercise of the centre's jurisdiction. And this was the ruling made by the tribunal in Spirida, Rosales, and Romania in 2011. However, the tribunal in another case, in Goose and Republic of Burundi case, took a different approach, where the Goose tribunal in 2012 made it possible for the counterclaim to be based on the treaty without being expressly mentioned because the general consent of the whole state to arbitrate was sufficient. And the third issue is on the sources of investors' obligations. The tribunal usually distinguish the investor's general obligation under the domestic law of the host state and obligation arising out of an investment agreement. So typically, a tribunal's competent rational material is only applicable to the sources of the investor's obligation that derive from the investment treaty rather than the one that derive from the domestic or national law of the host state. And in 1998, the tribunal in AMCO, Indonesia, affirmed these positions that obligation not to engage in tax fraud is clearly a general obligation of law in Indonesia. It was not specially contracted for in the investment agreement and does not arise directly out of the investment. So for this reason, the tribunal in AMCO finds the claim of tax fraud beyond its competent rational material. So the tribunal in AMCO can dismiss a counterclaim brought by Indonesian government. And the fourth issue is the unilateral character of the BIT. And it is often argued that because the object and purpose of the BIT seek to protect the investor rather than the host state, it provides no basis whatsoever for the state to assert counterclaim. And traditionally, a BIT imposes no obligation on the investor, but only on the host state. So that is based on the language of the older generation of the BIT. For example, Article 9, Greece Romania BIT stipulates that dispute between an investor and the other contracting party, which is the state of Romania, concerning an obligation of the latter, the state, under this agreement, in relation to an investment of the former, the investor, shall, if possible, be settled, or the investor concerned may submit the dispute to arbitration. So this is the classic example of unilateral character of BIT that contained in Article 9 of Greece Romania BIT, where the majority of the panel in Rosali's case found that this was a narrow offer to arbitrate relating only to investor claims and not a consent to arbitrate counterclaims. And the last issue that I'm going to highlight here is the state non-compliance with substantive and procedural requirements under arbitration rules such as on suit trial. And counterclaims have been challenged on the basis of pleading deficiencies due to the non-compliance with substantive and procedural requirement contained in the arbitration rules. And in the past, the tribunal have dismissed the respondent counterclaim because of this procedural irregularity with arbitration rules. So we have the cases of Offshore Mongolia, Event Costa Rica, and also Semester Ghana. The recent one was Event Costa Rica in 2018, where the tribunals concluded that although it had prima facie jurisdiction over the counterclaim, the respondent counterclaim failed to satisfy the procedural requirements to particularize its counterclaim in an adequate manner according to Article 20 and 21 of the Ancestral Arbitration Rules. Now, allow me to conclude my presentations with a way forward to enhance state access to justice in ISDS. First, the language of the BITs needs to be expressed in a broad and clear manner to empower a state assertion of a counterclaim against the investor. So as long as the counterclaim is closely connected, we satisfied a close connection test that was laid out by the tribunal in Glockner case and also Saluka case, the tribunal should find its jurisdictions because the BIT recognizes the state right to assert such a counterclaim. And second, an incorporation of express consent, which is indispensable requirement according to Article 35 and 46 of the ICSID conventions. Express consent to arbitrate counterclaims in the BIT will enable the incorporation of express consent of counterclaims in the BIT will enable the tribunal to extend its jurisdiction to hear the state's counterclaim in the same proceedings with the investor's claim. And third, increased recognition of a state right to regulate in the form of an exception clause, which appear in the new generation of the BITs. In areas related to public interest will oblige the investor to comply with the host state law. So in that case, investor can no longer argue that the sources of his obligation only arise out of the investment agreement, but not under the host state domestic law. Hence, the tribunal jurisdiction is wider, where a breach of the host state law is arbitrable through a counterclaim than merely a submission for a hearing in the domestic courts. And fourth, the BIT has to contain provisions requiring the investor to comply with the host state law. So this will strike a balance to ensure that a BIT is no longer unilateral towards the protection of investment only, but also reserve the host state right to assert counterclaims against the investor. So a breach of these obligations give rise to a counterclaim under the BIT. And finally, a state cannot overlook the importance of compliance with the substantive and procedural requirements of the arbitration rules. Therefore, strict compliance with the rules of pleadings set out by the arbitration rules, for example, Article 2021 of the Arbitral Arbitration Rules, will enhance the prospect of a counterclaim success. So with that, I finish my presentations. This brings me towards the end of my presentation. I welcome any question during the Q&A sessions once this event is over. So now I'll pass the floor back to Jayashree. Thank you for your attention.
Thank you for your presentation, Dr. Shahrizal. We'd like to remind participants to keep their questions coming in via the Q&A box. Introducing our next two speakers from India who have contributed on the chapter on the 2015 India Model BIT and its suitability under ISDS. First up, we have Mr. Pallab Das, who is an assistant professor at School of Law, Bennett University, India. He has completed his LLM from Swansea University, United Kingdom on an International Excellence Scholarship in 2015, with a specialization in International Commercial and Maritime Law, and his BSL LLB from ILS Law College, India. He completed his diploma in International Commercial Arbitration from Austrian Arbitration Academy, Vienna in 2018. He has written many articles as well as a book entitled Justice for Women Legal Compendium. He's also the editor of the book on maritime law through the lens of maritime law, a world view, and the editor of the second edition of the book Maritime Jurisdiction and Admiralty Law in India. He has practiced in the High Court of Orissa and worked as a civil judge, Odisha Judicial Services. He's a member of the Chartered Institute of Arbitrators and an associate member of AIADR Malaysia. Secondly, we have Ms. Rose Maria Sebi, who is currently pursuing BBA and LLB degrees at National Law University of Odisha, India. Her areas of interest include international commercial arbitration law and investment arbitration law. She has authored articles on commercial arbitration in India. She has also participated in moot court competitions, including a competition on international commercial arbitration where her team finished as quarterfinalist and was adjudged the team with the best written submissions. She has previously interned with lawyers and at law firms practicing domestic and international commercial arbitration. On that note, over to the both of you.
Thank you, Jayashree. And thank you everyone and AIADR for giving this opportunity, writing the book as well as discussing it today in this webinar series. Now, before I start, I would like to give special thanks to my two co-authors, Rose as well as Sandeep Gulani, who couldn't be present here today because of personal reasons. They have been the driving force for this paper to be successfully published in the book. I also thank Alan and Ben for giving us this opportunity. Now, before we start, I would like to say that rather than, we don't have a PPT as such, but we thought of having a kind of a discussion between both of us so that it gives more analytical overview of the paper that we have written. So what we do is that I'll be introducing the paper and talking a little bit about the scope of the paper, the chapter that we have written, which will then be taken over by Rose in discussing the points. And then I'll be again coming back, discussing few points, and which will then be concluded by Rose. I think as a team we'll work today. And the topic for discussion or the chapter today is the 2015 India Model BIT and its suitability under the ISDS. Now, we all know that India had previously a 2003 model BIT, but because of the huge amount of claims which went against India thought a need to change the BITs, and then later on in 2015, which is generally being termed as a 2016 model BIT, but in fact it was adapted in 2015. So the overall genesis of this of the chapter is the approach that India has taken towards BITs post a lot of claims by foreign investors? And is there any lacuna in the present 2015 model BIT? We basically emphasize on two very important aspects, one being the exhaustion of local remedies and the other being the MFN clause. Whether the present 2015 model BIT consists of these two things or not, we'll be discussing that. And the relevant clauses, especially in the differences and commonalities of the Indian model BIT and ISDS can still survive despite of the differences that is there. And finally, we will be talking about whether India should become a member of the ISDS or not. Okay. So with regards to this, I would like to first start that BITs are generally for the protection of foreign investors, and otherwise there could be advantages for the host state for the domestic legislations, as we all know. So the investment treaties are a unique way for every country, in fact, but there are certain features which differ in every country. For example, we can take national treatment, fair and equitable treatment, protection against expropriations, and access to a neutral forum for dispute settlement. But majority of the cases that India has seen till date, where the foreign investors have gone to international arbitration. And that is why we thought that there is a need to reform the present 2015 India model BIT rather than maintain the status quo or change it totally with the new model BIT. And with this, and the reason is because India, post the 1990, when there was an industrial boom and when there was a foreign direct investment boom in India, India became globally $44.8 billion USD market. And it is expected that by 2030, India will become the third largest economy. And that calls for a special need to focus on various aspects of the model BIT, because I think a lot of countries, a lot of companies will want to invest in India because it is still developing. And if we look into globally, if we look into different BITs, all BITs have been successful in some way or the other when it is with developed countries. But when there's a BIT between developed country and a developing country, a lot of dispute arises in terms of protection. And that is why we first talk about exhaustion of local remedies. I now hand over to Rose to talk about the exhaustion of local remedies. Yes, to you, Rose.
Thank you, sir. Before I start with discussing exhaustion of local remedies, I must say that I'm extremely humbled to be a part of this panel, which has lawyers who are much more senior to me. So thanks to AIADR and our editors, Bell and Allen, who allowed me to be a part of this. I'll now start discussing the chapter. I'll pick up from where Pallab sir left. The reason, in this chapter, we're looking at India's approach to towards ISDS, and the means through which we're doing it is by looking at the model BIT. Now, a model BIT is important because it gives some sort of consistency and uniformity in the BITs that a state enters into with other BITs. And it also shows or reflects the kind of investment, foreign investment regime that a state might have. And accordingly, the kind of protection or the extent of protection that it might be willing to give to its investors. And that's precisely why we're looking at India's model BIT. And when it comes to the investment treaty regime, we see that in India's case, there were basically 3 model BITs that we had over a span of 3 decades. We started with the model BIT in 1993, then we had one in 2003, and finally the one in 2015. So if we were to look at each of these model BITs, we can recognize the kind of investment regime that India had in these 3 decades. So to begin with, in the 1990s, up until that point, India was a closed economy. It was isolated from the rest of the world, but it opened up its market in the early 1990s. When the Indian policy makers decided to adopt policies of globalization, liberalization, and privatization, and that's when when India was open to the rest of the world for trade. And so even though up until that point, India had not entered into a BIT with any other country, in the context of India, a BIT became relevant. And so we had a model BIT in 1993 itself. But that particular model was based on the OECD Draft Convention on Protection of Foreign Property. And as the name suggests, the idea of that draft convention was to protect foreign property. It was very investor-centric, and it was one that was drafted by developed nations and was probably not something that could be in the best interest of a developing nation that's acting as a host state. But nonetheless, that's the BIT that we had adopted at that point as a model BIT. And subsequently, in the year 1994, we entered into our first BIT with the United Kingdom, which was based on the 1993 model. And from there on, almost all our BITs were based on the 1993 model. Now, to be specific about the kind of, about the way in which we adopted the 1993 model, we can look at the exhaustion of local remedies. So here, up until say the late 2010s, the BITs that India entered into was based on the 1993 model, where where the dispute resolution clause had a wider scope, which meant that there was no need, there was no requirement to exhaust local remedies. Instead, investors could directly initiate arbitral proceedings, and this is exactly where the change happened sometime in 2011. Because we recognized that there was a need for a change with this particular clause of dispute resolution. And the reason was that India saw that it ended up being a respondent it ended up being the respondent host state when many claims were brought against it in the international arbitration scheme. And so it recognized that it needed to review its investment treaty regime. And the decisive moment here was the Byte Industries case, where in this case, basically the UNCITRAL, an ad hoc tribunal that was following the UNCITRAL rules, said that because there was an inordinate delay on part of the Indian courts in giving justice to the case at hand, India is supposed to pay a huge amount of compensation to the investor, which in that case happened to be Byte Industries. So that was the decisive moment when we recognized that there was a need to change with respect to the exhaustion of local remedies. And accordingly, from 2012 onwards, there was a drafting committee which was set up, and then eventually in 2015 we had a new model BIT. Now, the way in which the exhaustion of local remedy is enunciated in the 2015 model is that when there is a dispute that arises, the investor has the option, has to first exhaust local remedies for at least 5 years. And after the 5 years that it exhausts local remedies in domestic courts in India, it can then, after the exhaustion of 5 years, it then has to have a 6-month period where it allows for the dispute to be resolved amicably. So it's only after 5.5 years that a claim can be brought to an arbitral tribunal if it's not resolved through exhaustion of local remedies and through the amicable settlement. And then, of course, after the 5.5 years, the investor will have to submit a claim to the arbitral tribunal, to the International Arbitral Tribunal, with a notice period of 3 months. So essentially, all in all, what that means is that after an action has taken place which has caused the dispute, the investor will have to exhaust local remedies, try to settle the matter after the exhaustion of local remedies for 5 years. And it is only after a minimum of 5 years and 9 months that it can finally go into an international investment arbitration. And this is something that could be seen as slightly problematic because it can cause an inordinate delay, because 5.5 years is a long time. But that's not to say that exhaustion of local remedies itself is problematic, because this is not something that is uncommon. We see several BITs between many states, both developed and developing nations, that require the exhaustion of local remedies. We see that with Netherlands, we see it with Singapore, we see it with multiple states. So it's not uncommon, and it's not particularly, and I wouldn't criticize it particularly, but in those instances, the requirement to exhaust local remedies is for a period of 180 months, as opposed to the number of years, as opposed to the timeline that is there in the India model BIT, which is of after the settlement of after the amicable settlement period, it ends up being almost 6 years, a little short of 6 years. So it's the timeline which is problematic. Another thing which is problematic about the dispute resolution clause is that it's an intricate one and it's a multi-tiered one, but the amicable resolution follows the exhaustion of local remedies, which means that they're trying to go into an amicable resolution after having undergone an adversarial process. And this process is likely to antagonize the two parties. And at that stage where they've already fought it out in local courts for almost 5.5 years, for almost 5 years, it might not be the right juncture to amicably resolve disputes. We usually would see in multi-tiered arbitration clauses that the mediation process or the negotiation process comes before actually going to courts or going to an arbitration or any kind of adversarial process. So this kind of the order in which it's given in the model BIT may not be the best one. So our suggestion has primarily been that we need to switch up the order, and also the period of 5 years and 9 months could be very long, because it's possible that with the kind of disposal rate we have at ICSID, it's possible that within that time the matter could be disposed if it were to go to arbitration, and they wouldn't have to wait for 5.5 years. So that's precisely what we saw with the exhaustion of local remedies. Pallab sir will now will be talking about the MFN clause as well.
Thank you, Rose. Now, keeping the time in mind, I will give an overview of the MFN clause that we are discussing. Now, MFN clause, as we all know, is that the most favored nation clause. It is there in one treaty, and if another foreign state invests, let's say in India, who already has a BIT with another nation, it can borrow any of the substantive and procedural clauses through the MFN clause. Now, this is what is the exact understanding of an MFN clause. Now, but there are two underlining or or one major underlining that when the new investor state tries to borrow, it needs to keep in mind that the subject matter of both the BITs must be the same. And it is then that you can borrow through the MFN clause any of the substantive or procedural clauses from another BIT. Now, and there is no bright line that we can follow, but we must keep in mind that the subject matter of the treaty should play an important role when when one investor state is trying to borrow it from the another BIT. Now, based on this fundamental aspect, there are serious problems because of the MFN clause. Now, what we have seen in different cases is that the tribunals are inconsistent while applying the MFN clause. A set of tribunals, in a set of cases, they have allowed importing dispute resolution clauses through MFN. So for example, if there is A BIT and B BIT, some tribunals have allowed the B BIT parties to import through MFN clause the dispute resolution clause that is mentioned in A BIT. Whereas in other set of cases, the tribunals did not allow. There is an inconsistency which is there. Now, this is one aspect of the MFN clause. The second aspect, being India being a developing nation, India has to be more careful. Now, what we have seen is that there was only one particular MFN clause in the based on the 2003 model BIT, which was found in the BIT between India and Bangladesh in Article 4, Clause 1 and 2. What does it state? I'll just quote so that you all can understand what it was there, that each contracting party shall accord to investments of investors of the other contracting party treatment which shall not be less favorable. Now, the 2015 model BIT does not mention at all about an MFN clause. What we are trying to say is that this is not a good idea to attract investment. So what we are approaching rather is we are suggesting that let us have twofold approaches and let us include an MFN clause. Now, what are the twofold approaches? One is a restrictive approach and the other one is a prospective approach. Now, what do you mean by restrictive approach? Now, in the restrictive approach, in the restrictive approach, what we basically want is, in the BIT, you mention the articles from the BIT to which MFN does not apply. So no importation can take place. Okay, so you say that only these clauses can be imported from any other BIT through the MFN clause. This is the restrictive approach. And the second approach that we are suggesting is the prospective approach. Now, what do you mean by prospective approach? It means that all the clauses, if you're trying to apply in another BIT, it will apply from a point of date, and you cannot import other clauses before that point of date. For example, if India has entered a BIT in the 1990s and we have entered into a BIT in 2019, and in 2019 we have specifically mentioned that you can import any of the clauses through MFN only from 2005. So if there is any BIT previous to 2005, you cannot import any of the provisions that is there in the BIT before 2005. So this is the prospective approach that we have taken. Now, why did we take this? We took this approach, both the approaches, seeing the fact that there was a lot of inconsistency in terms of application of the tribunal, application of the MFN clause by the tribunal. Therefore, what we are suggesting is we tried to come up with a clause and I shall narrate the clause right now, that investments made by investors of either contracting party in the territory of the other contracting party shall receive treatment which is fair and equitable and not less favorable than that accorded to investments made by investors of any third state post the bringing into force of the 2015 India model BIT. Now, this is the prospective approach that we are suggesting. Now, pursuant to such a provision, an investor would not be allowed to use the provisions or rights granted to investors in the treaties signed before 2016 with India. Now, the reason for making the clause prospective and asserting the designated date to be the date on which the model BIT was received is because since that date, only 2 agreements containing a restrictive MFN clause were entered into by India. Now, this limitation protects the host state, if India is the host state, from investors using the wider MFN clause that were entered into by India prior to the revision of the model BIT. Now, this gives India an opportunity to carefully determine the usage of the MFN clauses in the future and limit the extent to which the clause can be used. Now, why did India do this? Again, because as Rose spoke about the White Industries case, which was a very famous case, and India, if I'm not wrong, India had to pay a huge amount. It was a 3-digit amount. Rose, if you can help me with the amount, around 400 million dollars was given as a compensation by India. Now, because of this, India thought that it is required that we must change the regime right now. And out of the total 84 total BITs India has signed till date, I think it unilaterally cancelled around 60, or if I'm not wrong, more than 60 BITs. And post the 2015 model BIT, India has entered into only with 2 investment treaties. And so, I mean, concluding this point on MFN, it is our suggestion that India should consider having both a prospective as well as a restrictive MFN clause that excludes its importation from previously signed BITs and also prohibits its application to dispute resolution retrospectively. This is very important. Now, what will happen if this is there? Foreign investors would not indulge in treaty shopping, and it would also, the aspect of non-discrimination will also be not there. And this will also facilitate both development as well as more inflow of FDI. Now, this is the overall view. I have specifically not gone into the details of the cases, and I reserve this for the readers to read in details, but this is the overall structure of the MFN clause that we are talking about, the suggestion of the prospective as well as the restrictive approach. To you, Rose, to the third point that we are discussing regarding being member of the ICSID tribunal.
Thank you, sir. The amount of compensation that India had to give was $4.08 in White Industries.
US $1 million, if I'm not wrong.
$1 million, yeah. Yeah. So moving on to the third part of the chapter, the question we're asking in the third part is, should India become a member of the ICSID? And the reason we're asking this question is because we want to see how will investors enforce an investment arbitration award in India. Because the way in the Indian context, enforcement of awards, arbitral awards is done through the Indian Arbitration and Conciliation Act, which has basically, in terms of enforcement of awards, has adopted the New York Convention. But there, India has taken the commercial reservation in the New York Convention, and also the Indian Arbitration Act allows for enforcement of commercial arbitration awards. So the question really that comes up is what happens to investment arbitration awards? With this regard, in this regard, there is an ambiguity in the Indian context. Because when we look at commercial arbitration awards, whether it's domestic or international awards, we see that Indian courts have been pro-arbitration and they have enforced arbitral awards. But the ambiguity lies with investment awards, and the ambiguity precisely is because two courts in India of the same level have given a differing opinion. So the High Court in Calcutta says that the Arbitration Act of India, which allows for enforcement of arbitral awards, does not includes investment awards, whereas the Delhi High Court in India says that the Arbitration Act does not include investment awards, and it only includes commercial awards, commercial arbitration awards. And that's precisely the problem with respect to enforcement of arbitration awards. Now, for an investor to be able to, but this is not to say that it's not enforceable at all. It's just the point that there is an ambiguity with regards to an investment arbitration award being enforced. For an investment arbitration award to be enforced, one of the ways to solve that issue for an investor would be if the Indian legislature amended the Indian Arbitration Act to include investment awards, or if a higher court in India, which is the apex court in India, the Supreme Court, were to say that the Arbitration Act includes investment arbitration awards. That would solve the problem. But if that doesn't happen, if there's no change in the Indian law, then another way to go about it would be for India to ratify the ICSID Convention, become a member of it, and then implement the legislations in India, which would allow for enforcement of arbitration of ICSID awards. And this would help enforcement of investment awards, because investors would then have the option to at least enforce awards through ICSID, which in any case is one of the most preferred forum for investors. So that's so the problem of investors being able to enforce awards in India could be solved either through a change in the legislation in India. And if India doesn't want to go through that channel, then of course it could limit investment awards to ICSID, which is reliable and popular among investors. So that should also solve the problem for India. So that was our chapter. Those were the things that we discussed in our chapter, which, and to sum up, it's, okay, I see a question, but.
We can take that during the question answer round. Yes.
Okay, yeah, I will. But to sum up, India has adopted a model BIT, and the experience that we see after the adoption of the model BIT is that it has not necessarily followed everything according to the model, because India did, like Pallab said, we did terminate many of our BITs, but after the adoption of the new model BIT, we did enter into BITs with countries, and not necessarily did we follow them. For example, with Brazil, we entered into a BIT earlier this year in January, and the exhaustion, and it allows for states to go, and it does not require states to exhaust local remedies. So even though there are things in the model BIT which may not be the best suited in the ISDS system, what India has been following has in some cases been in lines with the model BIT, and in some cases it has not been. But what we tried to do with this chapter is suggest what could be ideal for India as a host state, in a manner that it balances the interest of both the investor and the host state, and is not just investor centric in a manner that it was maybe 2 or 3 decades back. That's all. Thank you. And I think I've exhausted my time as well.
Thank you. Thank you, everyone. Thank you. Over to you, Jayashree. Thank you.
Thank you, Mr. Pallab and Ms. Rose. Introducing our final three contributors from the United States of America who have contributed the chapter on regulating third-party funding in investor-state arbitration through reform of ICSID and UNCITRAL arbitration rules, holding global institutions to their development mandates. First up, Mr. Frank Garcia, who is a professor of law and Dean's Distinguished Scholar at the Boston College Law School. A Fulbright scholar, he has lectured widely on globalization and international economic law in Europe, South America, and the Asia-Pacific region. He's the author of, among other volumes, Consent and Trade, Trading Freely in a Global Market 2019, and Global Justice and International Economic Law, 3 Takes, both published by Cambridge University Press, and a co-author of Rethinking International Investment Governance, Principles for the 21st Century 2018. Professor Garcia is a senior fellow of the Columbia Center on Sustainable Investment and a member of the editorial board of the Oxford Journal of International Economic Law. Second, Mr. Michael Garcia is a litigation associate at the Boston office of a global law firm. Michael is a 2016 graduate of the University of Michigan Law School, where he was a member of the Michigan Journal of International Law and an executive board member of the Michigan chapter of the Syrian Accountability Project. While at Michigan, Michael was named a 2015 Geneva International Fellow and spent a semester at UNICEF's office in Geneva, Switzerland, advocating for children's rights at the UN Human Rights Council. Michael's article entitled Clayton Wilkin, Investor-State Arbitration and International Approaches to Trade and Investment was published in volume 13 of the Manchester Journal of International Economic Law. Finally, Mr. Karl Lockhart has worked as an associate specializing in international investigations and disputes at a global law firm. Twice seconded to the firm's Singapore office for matters in South and Southeast Asia, he also has extensive experience in Africa, having worked on development projects in Tanzania, interned at the World Bank in South Africa, and researched human rights issues in Zambia. He was elected to the Order of the Cloth at the University of Virginia School of Law, where he received the Monroe Lee Fellowship in International Law and was a member of the Virginia Law Review. His articles have been published in the Virginia Law Review, the Boston College Law Review, and the Georgetown Journal of International Law. With that being said, over to you, gentlemen.
Thank you very much, Jayashree, and good afternoon, everybody. On behalf of myself and my co-authors, Michael and Karl, and Brooke Govan, who was not able to join us, I wanted to thank the Institute for hosting this book launch, and thank as well Alan and Ben for having pulled together such an interesting volume on such an important set of topics. Now, my co-authors and I have a chapter on regulating third-party funding, as was said. And I think with this audience, we can assume some familiarity with third-party funding, but just briefly to define it, our subject, our concern is about financial investment in an ISDS claim by third parties in exchange for a non-recourse interest in any award that results. So my co-authors and I will be sharing this time. I will be introducing a few issues at the beginning and then turning it over to Michael and Karl and then coming back at the end myself. But all of us share a concern about the negative effects of third-party funding in investment arbitration. In our view, nothing short of the survival and the integrity of the ISDS system depend upon regulating third-party funding. Now, third-party funding represents itself to be an access to justice tool or a neutral mechanism for balance sheet management. But in fact, we think that's misleading and not the case. In fact, third-party funding turns the ISDS system into a mechanism for speculative investment rather than a system designed to support development and protect investors of productive investment. In short, through the introduction of third-party funding, finance and not investment will be driving the bus. And one indication that this is the case is when we see litigation funding sources like Burford Capital announcing proudly that they have received returns on investment as high as 700% through their investments in ISDS cases, we know that that is not a sustainable level of return on investment, and in fact represents a form of speculation and not traditional investment as the system is designed to protect and to advance. And that's one of the reasons why traditionally in common law systems, maintenance and champerty, as they were called, were not permitted. It was not permitted to invest as an outsider in other people's lawsuits. And it was the revisions to those doctrines that began to allow third-party funding in common law jurisdictions. Now, the reasons for maintenance and champerty having been prohibited under the common law, and reasons for our concern today about the role of third-party funding in ISDS, is that third-party funding distorts the incentives and the decision-making that are a part of the ISDS process. Depending on the funding agreement, and all of this is subject to a great deal of secrecy, and that's why many reform proposals focus at least on disclosure and transparency. But depending on the funding arrangements and the details that we have available to the public record, third-party funders, in fact, will become involved in decisions about case management that fundamentally affect the way these cases proceed. They will be involved, of course, in what cases to bring, what arguments to make in the cases that are brought, what arbitrators to choose, and in particular, whether or if to settle the claim or not. Now, these, of course, are decisions that any traditional investor will make in the management of their own claim. But through the mechanism of third-party funding, these decisions are now being influenced by the speculative financial community rather than the traditional investor whose claim it is in the first place. And therefore, the incentives and the rhythm and the rationale for these decisions are going to be influenced by the goals of speculative finance and not by the goals of the traditional investor and the concerns for the underlying relationship between investors and states, which is a fundamental value of the system. So a second point is that ISDS, in fact, third-party funding in ISDS, in fact, is leading to a tremendous additional burden on states. As we know, third-party funding is realistically only available to investors and not to states. So we are adding a tremendous financial resource behind one of the class of parties to these disputes, which is unavailable to the other class. And it's being added by a community, speculative finance, that faces little to no downside risk involved in these cases. All they are putting in is the cost of running the case. And if they lose $10 million. But if they win, they get 30 to 50% of awards that could be 300, 400, 500 million or higher. So this is what's led investment arbitrators to comment that this is like a gambler's paradise. Heads I win and tails I don't lose. Now, it's very sobering when you realize that from the evidence we have available, the number of claims is rising significantly through the presence of third-party funding. Not only is the number of claims rising, but some of the weakness of the claims is increasing because these claims are being bundled into portfolios by the finance community. So they can afford to take risks and place riskier bets because the costs of these cases are spread across the portfolio of claims. However, from the state's point of view, what the states are running into is that the costs involved in defending against these claims, in settling these claims, or in funding any award are increasing tremendously. And these costs are all being borne by the public treasury of largely developing countries. So it's when you connect all these dots that you realize that the role of TPF and ISDS is really not to promote access to justice or to simply offer a neutral tool for balance sheet management. But in fact, it's to turn the system of ISDS with its particularities and shortcomings away from a system to support the sustainable development of states and the protection of productive investment into a mechanism to generate tremendous short-term profits to the speculative finance community. And it's for these reasons that we consider that any party that has an interest in the stability, integrity, and legitimacy of the ISDS system should be concerned about the effects of third-party funding within that system. So what should be done about this? Well, this is where I'll turn it over to my co-authors, Michael and Karl.
Thank you. Just want to say a quick thank you to our hosts and to the other panelists for their perspectives. With that, I'll go ahead and go ahead with my section. I know we're trying to preserve some time at the end for Q&A. So an effective response to the costs and risks of TPF and ISDS, discussed briefly by Frank, requires that reform efforts proceed on several fronts. In treaties, through arbitral association rules reform, and in domestic law, as we've outlined in our chapter. Investment treaties are a logical starting point for reform because any restriction or regulation of TPF provided for in the treaty applies to any dispute brought under the treaty, regardless of what rule seat are chosen. So in some ways, treaty reform may be the most straightforward approach to overall TPF reform. The addition of one or two provisions restricting TPF or requiring disclosure, particularly in treaties involving major economic players, can have a profound impact on the use of TPF in future global disputes. However, there are drawbacks to relying on this approach, which I will touch on briefly. Currently, the vast majority of international investment agreements are silent on TPF and do not contain any provisions banning or restricting its use or requiring its use to be disclosed. However, we are seeing the effects of the growing influence of TPF in international investment in some of the recent IIAs and the model treaties, which incorporate provisions restricting or otherwise regulating TPF. A notable example is the 2018 bilateral investment treaty between Argentina and the UAE, which contains an outright ban on third-party funding of claims. On the other hand, the EU's recent investment agreements, while not restricting TPF, do require disclosure of the existence of TPF. Australia and Indonesia's recent BIT is another example outside of the EU where disclosure is required. In addition to several of these new treaties, the model BITs of the Netherlands and Slovakia require disclosure of TPF as well. So these treaties are an important step, but they leave much to be desired. For example, all of these new treaties and models do not contain definitions of TPF, and penalties for violations of treaty terms regarding third-party funding are left to the discretion of the tribunal. A more effective and comprehensive regulation would require, specific terminology, defined terms, specific penalties and enforcement procedures. The drawback to relying on reform through new treaties is therefore that new treaties are rare and that most are still brought under generation treaties concluded in 2010, which do not address the recent ascent of TPF and ISDS. Thus, any treaty-based approach would also require amending existing treaties, either on a bilateral or multilateral basis. Amendment on a large scale is possible in theory, but practically speaking, there are many hurdles which we can discuss in a Q&A. On the other hand, amendment through a multilateral instrument is more attractive in some ways, namely in terms of benefits in scope and uniformity to amending bilaterally, but negotiations can take years, and to the extent capital exporting states do not ratify the treaty, or investors retain ability to treaty shop around its effectiveness will be limited. Due to these challenges, to address TPF comprehensively by means of a purely treaty-based approach. An investment reform will remain an important piece of the regulatory puzzle, but we need to consider, but it will be fragmented by nature, and the political economy of treaty reform is not least. As Karl will discuss in more detail, we believe instead that the key to an effective and efficient response to the costs of TPF and ISDS will depend primarily on arbitration rules reform. And with that, I'll turn it over to Karl.
Thank you, Mike, and thank you to all of our hosts and other panelists. Very, very happy to be a part of this. So as Mike just discussed, treaties have some issues with serving as an avenue to reform. So our book chapter focuses on arbitration rules, and in particular, we look at ICSID and UNCITRAL rules for arbitration, and by changing those rules, being able to regulate or restrict TPF in investment arbitration. So first I'll talk about why these rules, why should we focus on ICSID and UNCITRAL? And there's two reasons for that. The first one is that this is a very efficient way to address the issue of TPF, because our research has found that almost 90% of investment arbitrations took place through either ICSID or UNCITRAL rules. So if you were to modify those rules to include provisions that address third-party funding, you would be covering virtually all investment arbitrations that take place. So that's an argument from efficiency. There's also a policy argument, and that goes to the title of our article, which is holding institutions to their development mandates. ICSID and UNCITRAL are arms of the World Bank and the UN. And those two global institutions' goals are to promote sustainable international development, in particular with an emphasis at looking at the rights of developing nations and the world that is trying to receive capital. And they're supposed to care about global growth and prosperity, both of these institutions. And as Frank mentioned at the beginning of this discussion, we have some serious concerns about the way that TPF affects these developing nations and the way that these nations are targeted through TPF and through third-party funders. So if the UN and the World Bank want to adhere to their development mandates, they need to address this issue of TPF, and they need to do it through reforming their arbitration rules, through the ICSID rules and through the UNCITRAL rules. So that's our policy argument for why these set of rules. So we have those two arguments. And then I'm going to turn to ICSID and discuss the current rule reform process that's happening there, because what's interesting is not only are these two institutions the best ways to address TPF, but both of them are actually involved currently in rule reform. So they're now open to changing their rules and potentially addressing TPF. So ICSID, as Rose mentioned, is a very, very popular forum for resolving investment disputes. We heard a little bit about whether or not India would join, and there's a good reason why they might, and it's because it is the most popular forum for investment arbitration. And ICSID also is undertaking a rule reform process, as I discussed, and TPF is one of those topics of discussion. But right now, the issue is that the proposed rules are limited to disclosure. And in particular, they only require the disclosure of the existence of TPF and the name of the funder. And that information only goes to the other parties and the arbitrators. Now, this is a good first step because this addresses conflict of interest issues. So you wouldn't want a funder to have some interest, or an arbitrator to have some sort of interest in the funder, or vice versa. You want there to be disclosure of that between the parties. That is good. But the problem is that it doesn't address the systemic issues that Frank began this discussion with. And the way to begin to address that is to make that information also public. So not just to the tribunal, but to the public at large, so that academics and think tanks and others can study the way that TPF is being used in ICSID arbitrations. And that public transparency is essential to assessing what is happening, because right now so much is happening in the dark that we can't tell how much this is being used and how it's being used. And if the concerns that Frank raised at the beginning of our conversation are not true, then third-party funders shouldn't have a problem allowing this data to be public to validate their claims. It will prove their point if our claims aren't true. But what we do need is the data. And the only way to get that is through the disclosure of funding and who the funders are in every arbitration that takes place in front of ICSID. So that's what we would advocate for in a proposed rule reform that's happening right now at ICSID. And with that, I'm going to turn it over to Frank to talk about the rule reform process that's happening at UNCITRAL.
Thanks, Karl and Mike. As Karl mentioned, UNCITRAL's reform process is a marked contrast to the one that's going on at ICSID. And UNCITRAL recognized early on, as far as 2015, that there were a number of states involved in the UNCITRAL process that had significant concerns about the role of third-party funding because they were on the receiving end of these claims and cases. And so it was decided early on in the UNCITRAL rules reform process, specifically in the work of Working Group 3, which is tasked with ISDS reform, that third-party funding was an important topic for the UNCITRAL reform process, and that it needed a multilateral approach. As part of that, Working Group 3 has developed an intentionally broader agenda for TPF reform than ICSID, which not only addresses issues of transparency and disclosure, and I should say these are all currently proposals that are being debated and discussed. There's no clear resolution yet of what reforms the Working Group 3 is going to decide. But the scope of the conversation is much broader. And proposals being discussed include not just sort of minimal disclosure that ICSID is requiring and that Karl was critiquing, but fuller disclosure to include not just the identity of third-party funding, the presence and identity of the funders, but also the terms of the funding agreement, so that the parties can assess exactly what type of control the third-party funders are exercising in the management of the case. And it goes farther to include considerations of whether or not there ought to be some sort of caps placed on a reasonable rate of return if third-party funding is to be allowed. Whether there should be any negative consequences for what are deemed to be frivolous claims that are being brought forward on the basis of third-party funders. Whether the presence of third-party funding should trigger a mandatory order of security for costs so that the third-party funders, in fact, have some actual liability attached to bringing forward this number of claims. And whether or not, in fact, if third-party funding is going to be allowed in access to justice cases, that the parties develop, that UNCITRAL develop some actual metrics for what is a valid access to justice situation, and not just a case where an entity is deliberately stripped of its assets in order to look like an impecunious claimant. And finally, the proposals go all the way towards a complete restriction on any role of third-party funding in investor-state arbitration. So it's when we consider the scope and the depth of the issues that are being addressed, the concerns that are being raised and the issues being addressed in UNCITRAL, that we can say that it's very important that the ICSID process take a close look at this, and that states and other parties involved in the system seek a broader and deeper scope for reform than what ICSID is currently contemplating. And I would just conclude by emphasizing that what's at stake here, and it's a stake for investors as well as any other party involved in the process, is really the stability and longevity of the ISDS system at all. We've seen very high profile defections from ISDS. We've seen important actors like India, South Africa, United States, Canada. At one time it looked like even Australia might withdraw, but that's not happened yet, from ISDS type remedies. And the presence of third-party funding is only going to exacerbate that trend. So for a whole host of reasons, it's important that the community of investment take seriously the risks that are posed by TPF and not lose this opportunity of addressing them through comprehensive arbitral association rules reform. Thank you.
Thank you, gentlemen. We will now proceed with a few questions posed by our audience. The first question reads, we will start with the question posed by Mr. Frank, posted to Kiran. A question, could you say more about how the exhaustion provision works in USMCA? If there is no ISDS for US and Canada, what happens to any USMCA claim after exhaustion of Canadian or US court proceedings?
Thank you, Jayashree, and thank you, Frank, for the question. I think the question goes to the heart of two different topics. The first being that Canada simply is not a party to Chapter 14 of the USMCA. And in that sense, it's also then not a party to the exhaustion of local remedies requirement, or even the fact that there is recourse to ISDS at all. And the second point that this touches upon and draws upon is actually the one that was discussed by Rose when she was talking about the idea of exhaustion of local remedies. I think Rose very nicely set the stage for what exhaustion's pros and cons can be. I think Rose took a negative view of exhaustion's a really challenging burden and hurdle to meet, and is it the right burden or hurdle to meet? And I'll take that idea and flip it on its head and say, well, what we're really talking about is a choice on whether sovereignty and what piece of sovereignty should be acceded. And the choice made by Canada in the USMCA is, look, we don't want recourse to ISDS. So any remedies you need to seek or any remedies you wish to have are identical to those available in other fora to any other investor, regardless of nationality, domestic or international. The choice is being very expressly made that they're not willing to accede that piece of their sovereignty. On the other hand, the exhaustion of local remedies requirement, regardless of how onerous or not onerous it may be to a particular investor in a particular setting, it reflects a choice that's being made to create an additional forum. And I think that's something that's recognized in some of the other chapters of the book as well, that there's an opportunity to create a forum. It's a choice. Then the state is making that choice, and the state may change its mind. And so that's exactly what we see in the transition from NAFTA to USMCA. Canada made a certain choice at an earlier point in time. It's now made a different choice. Now, there's one caveat that I haven't really acknowledged here, but there is an opportunity outside the USMCA for Canadian and Mexican parties to resort to ISDS with each other. And it comes out of a different free trade agreement or a different trade agreement. I mentioned that very briefly in the footnotes of the book chapter, but it's something worth just acknowledging that USMCA itself is not a be all end all to remedies that may or may not be available. So maybe there's a different way to reach arbitration between Mexicans and Canadians, or Mexico and Canada, but it's simply not available in USMCA. And that is simply the point, that you have reform and you have evolution, and it's a different choice of sovereignty being reflected there. Thank you for the question. Jayashree, back to you.
Thank you, Kiran. The next question, once again from Mr. Frank, to Pallab and Rose. My understanding is that an early draft of the 2015 Indian Model BIT had a very interesting approach to compensation, namely allowing mitigating factors in Article 5.7 to reduce any compensation due to the investor for reasons like liabilities owed to the host state or investor harms to the environment. But the final draft did not include such a provision. Can you comment on why this innovative approach was not included in the final draft?
Yes, thank you, Mr. Garcia, for this question. Well, to answer this question, I think this is more of a diplomatic question solution rather than a legal solution to this. Because what happens when the entire process takes place from the legislative until the execution of the regulations or the enactments of statutes that takes place, a lot of stakeholders are included in this. Now, what happens is political atmosphere plays a very important role in making of the final act. Now, one such example I can give you is that initially when there was a draft bill that was there for, I mean, in India, let's say for an XYZ Act, but which was a better bill containing a lot of provisions, both for the, if in case there is a dispute for both the parties, but ultimately, when the bill became an act, a lot of important aspects were not there. But I think this is just because of the political atmosphere that takes place while drafting of the legislation takes place. That is the only answer that I have for this question as of now. I think that plays a major role rather than any other aspect of it. I think that's it, sir.
If I may also add to what Pallab sir said, the earlier draft listed out several mitigating factors, and arguably a lot of them were not in favor of the investor and were more protective of the host state. This could, and the question then arises, how many of those mitigating factors are actually effective or reasonable? For instance, it says that if the investor has made a certain profit before so this entire mitigation factor is for the expropriation aspect. So if they have already made certain profits out of the investment, then that could be a mitigating factor when the investor has to be compensated for the expropriation. But then a counter question that could come across is that, forget about the profit that they have made. Think about the profit that they could have made had the expropriation not taken place. So while there are mitigating factors, there could also be corresponding aggravating factors. But of course, even if this is not covered under the BIT, it could perhaps be covered under the contract that the two parties enter into.
Thank you, Mr. Pallab and Ms. Rose. Mr. Frank, do you have any response to that?
Well, thank you. That was very, very interesting. It is, from a academic point of view, it's unfortunate that the politics would intervene in that way, because many commentators were quite interested in this Indian experiment, in part because it also touched some of the issues that Dr. Zin was raising. It was another way into the counterclaim problem by allowing these issues to be raised as mitigating factors. So I'm encouraged to think, as Rose just said, that the spirit of this approach might still survive in some of the individual investment contracts that might be negotiated, even if it's not part of the model BIT. Perhaps it could also be put into an actual BIT with India that goes beyond the model, but of course that would depend on the same politics. But thank you.
We have questions from the participants. We'll take one. Do ISDS protections or remedies differ from those available to domestic investors under national laws? Is there any member of the panelists that would take this question?
I think that depends on the national treatment aspect of the BIT. It may or may not be there. I don't think I can speak for, at this point, any other country other than India, but at least the model BIT that India had, and most of the BITs that we have entered into after the model BIT, and even the ones that we did before, did have national treatment included as a clause in the BIT. So yes, there is an obligation to provide equal remedies, equal opportunities to both. But of course, that doesn't extend to say a dispute resolution clause, which would be different for both states, or maybe taxation, which would be different for both states. So it really depends on what we're looking at. But in general, yes, national treatment is something that is there in most BITs, which does sort of equalize domestic and international players.
Can I please request Jayashri to repeat the question?
Yes, certainly.
Yes.
Do ISDS protections or remedies differ from those available to domestic investors under national laws?
Right. I mean, supporting what Rose said, if I can just think of one thing is that domestic investors will not enter into a BIT, first of all. What they will enter into is contractual relationships with the government. If I may correct myself in that sense. And in that case, what will happen is the issue of sovereignty will not come into picture at all. So for them, I believe what international or foreign investors can at max think about is borrowing some of the remedies that is available in the domestic contracts. But I don't think so that it will be, it is equal to domestic in terms of that. So I think that is what my understanding is, because domestic investment is totally different than that of the foreign investment that comes into picture, because a lot of foreign diplomacy plays, there's a role of foreign diplomacy that goes into the making of the BIT, whereas in the domestic legislations, that sort of things are not there, because both parties in that case are of the same nationality. So I think there is not equal division of remedies that you will find, but of course you can borrow it. That is what I can say. To you, Jesh. Thank you.
Could I perhaps add just one comment to that? I think just to build on what's been said, I think an important difference is that, and this touches the issues that were raised by Dr. Zin, that a domestic investor that gets involved in a legal proceeding under domestic law against their own state is, at least in theory, also liable to counterclaims and legal responses, legal actions by the state. Whereas under the ISDS system, a BIT ISDS system, generally speaking, a foreign investor will not face that risk in engaging and initiating a proceeding with the state. And I think that's a fundamental structural difference.
Are there any other panelists that would like to answer this question? We have a question for Dr. Shahrizal from Mr. Frank. Are you aware of any new BITs or BITs currently being negotiated that make the changes you suggest to allow for counterclaims?
Thank you, Mr. Frank, for these questions. In my opinion, the trend of widening the scope of claims under the BIT has started much earlier, in particular the case of Urbesa, Argentina. And if we look at the BIT between Spain and Argentina, in the case of Urbesa, Argentina, that was the first time when the court admit or extend its jurisdictions to allow counterclaims submission to be made because of the existence of Article 10 in the Spain and Argentina BIT, which incorporate a neutral language. So Article 10 says that it allows either party to submit a dispute in connection with an investment to arbitrations. And the tribunal in Urbesa saw this as a non-restrictions for the respondent, for Argentina to submit counterclaim as long as a dispute submitted was connected to the investment within the meaning of the BIT. So that is on the broader language or neutral language that we found in Article 10 of Spain, Argentina BIT in the case of Urbesa, 2011. And the other one, the more recent BIT, the new generation of BIT, such as in Malaysia, in Asia Pacific, we have used to be TPPA, before Trump walk over when he took the White House in 2016. Now we rebranded as CPTPP, Comprehensive and Progressive Trans-Pacific Partnership. So if you look into that, preamble, paragraph 9, article 9.16 provide exception clause, all right, to protect the state regulatory power to regulate the law in areas of public interest, to protect the environments or human rights or public health. So that is also one of the recent examples where a state already moved towards safeguarding its interest to regulate in the area of public interest, and not only under CPTPP, but also the same developments can be seen in other recent BIT, in CETA, Canada, EU, free trade agreement, Chile, Hong Kong in 2015, and also Canada and China. All right, and it remains to be seen whether or not the ongoing China, US or China, EU, BIT going to make any further changes in protecting states' interest to regulate. All right, so that's my answer to your questions. I think the trend is going to continue when it comes to carve out exception clauses. I think we have more upcoming BIT that preserve state right to regulate.
Thank you, Dr. Shahrizal. Any response to that, Mr. Frank?
Just that I think that's very good news, because I think, and this goes to one of the questions in the Q&A, and this is something that that Michael mentioned, reforming the BIT process sort of agreement by agreement is a very slow way to go, but it's an important way to go. And it's encouraging to see that some of those efforts are in fact underway.
Thank you, Mr. Frank. We have another question from the participants. Are there any improvements that can be done to the existing investor-state arbitration system? Any member of the panelists that would like to take this question?
Actually, perhaps I can just start with a general comment, which is that it depends on your perspective, and do you think that the existing system can be saved? I think is really the fundamental question, or should it be outright replaced? And that might sound like an easy question for me as an international arbitration practitioner. I hope the answer is yes, because I want to be employed and I want to have a job and I want to have cases to work on. But it's a fundamental question in the sense that is actively being debated, and there may not be a clear answer, especially with respect to the debates unfolding at UNCITRAL Working Group 3. I think a lot of stakeholders question whether this is the right system. One of the critics, strong critic in the US of the ISDS system is an organization called Public Citizen. And I talk about some of the critiques that they've made of NAFTA in particular, but of ISDS generally in my book chapter. And some of their criticisms mirror, I think, the broader concepts in this debate, which is ISDS legitimate? Is ISDS fair? Are these tribunals legitimate? The arbitral tribunals, are the tribunals fair? In my personal and humble opinion, I think yes, if the system is managed effectively. And in that sense, reform is the right approach. And in that sense, every piece of the system needs to be examined, modernized, and continuously evolving based on usage. That's my opinion. I think there are plenty of other people who have a different opinion saying absolutely not. This system should not exist. It's unfair inherently because it creates a level of protection and dispute resolution for certain members of the public, foreign members of the public, privileged members of a certain foreign public over everybody else. And that as a concept is unacceptable. But that is the nature of the debate. And I think it's the one that we all need to come to some kind of grounding on. And what might be shocking, and I think it can be shocking for certain individuals, is, well, why is this debate happening now? The ICSID convention has existed for more than 50 years. The idea of state-to-state or investor-state dispute settlement has existed for even more than 50 years. So why is this debate unfolding today? And I think they're practical. Again, this is why the experiential reality matters so much, as well. Nobody used this system for a long time. It existed and was underutilized. And so there was no experiential reality to help drive development of the system and refinement of the system. So I think we are at a critical moment where, NAFTA versus UMCA is a really great example. We're at a critical moment where there was enough experience that there was a reason to consider, well, replace, reform, or status quo, or is this even a really good idea at all for North America or in other contexts more broadly? So that might just be, I don't have an answer, but it's a really good question, is all I really have to say on that. And I think maybe the other panelists might have different views or more positioned views than I do.
If I could just add two comments to that. I agree with what Kiran has raised, and I think it's particularly valuable that she raises these issues in such a balanced way from within the international arbitral community. And I think she mentioned the significance of what's going on in Working Group 3 in UNCITRAL. This goes back to the point that Karl was making, that arbitral associations are such an important node for the entire system. So if these sort of comprehensive and structural issues are going to be addressed, perhaps the best place to do it is in arbitral association rule reform. And that's where the contrast between ICSID and UNCITRAL is particularly important. And my second point would just be to respond to the question in the Q&A is, if you want to know about reforms and improvements, buy the book and read the book, and then you'll know a tremendous amount about it.
Thank you, Ms. Kiran and Mr. Frank. Seeing that we are coming to the end of this webinar, thank you to our distinguished panelists for this very insightful session. AIADR congratulates and thanks all who have contributed towards this publication, and we wish it the very best. As Mr. Frank said, buy the book and read the book. As promised earlier, kindly find the discount code 25ISDS21, 25ISDS21 as displayed on the screen, and link to the Wolters Kluwer's site to purchase this book as displayed on the screen. The discount code and link is also made available in the Zoom chat box for participants. Okay. To end this informative session, AIADR extends a warm invite to participants to join our institute as a learner member. We have made the learner membership completely free of charge, which comes with various advantages such as right to use post-nominal letters, practice rounds for international moot competition, access to our resources, and many more. You can even join as a full-fledged professional member just by enrolling into our online course. We will also be offering comprehensive training through our Introduction to ADR forums, mediation, arbitration, and construction adjudication courses. These courses will be done by certified trainers and prepare you for practice in ADR or the use of ADR in any field. Upon completion of these courses, you will be eligible to sign up as full-fledged professional members of our institute and the opportunity to network with our high-profile members from across the world. Do keep a lookout for the launch of these training programs on our AIADR website and our LinkedIn page. You can also apply for the membership or training online at our website at www.aiadr.world. On that note, thank you all for coming, and we look forward to hearing from all of you.
Thank you, everyone, for this wonderful time. It was a great learning experience. I hope we all associate once again in near future. Thank you.
Yes, thank you, everyone, and wish you all the best of luck in these important endeavors. Thank you.
Yeah, thank you, everyone. Thank you, my colleague from India, and also to those from US. Thank you for waking up in the wee hour of the morning. And please let us know if you are able to travel to Kuala Lumpur after pandemic is over, maybe next year. So if you happen to be in Kuala Lumpur, Malaysia, so please let us know and keep in touch.
Thank you. We will.
All right.
Thank you, everybody.
Thank you. Thank you for everything, Jayashree. You did a wonderful job leading us through this process.
Yes, thank you for hosting.
Yeah, thank you for the thank you to the organizer for organizing a fantastic event.
It was our pleasure. Thank you.